We've talked a lot over the past 7 months about the devolution white paper. We now saw the Devolution Community Empowerment Bill has come out. Um, it is, that sort of in some ways breaks a bit of a sort of holding pattern that we've all been in as we sort of desperately sort of try and put proposals together post the white paper. We did some on the day analysis from that of the bill when it came out, but today as exclusively for LGIU members as a sort of follow on from that to really try and get into some of the challenges that the bill presents. We have to talk us through this. We call it Ask the Expert for a reason. I'm the asker, but the expert today is Laura Hughes, who's a partner at Browne Jacobson. Browne Jacobson are one of LGIU's founding strategic partners. We've done a lot of work with them over the years, and got a lot of exciting research coming out with them over the next year or so. Before we ask Laura to dive into the bill, I just wanted to flag a piece of research we're launching with Browne Jacobson today, looking at devolution, looking at some of the sort of capacity and governance challenges in devolution. This was based on interviews with people who have been through devolution in existing combined authorities. And it's basically about pulling out some of the practical realities of how devolution actually works. There's a bit of a tendency at the moment, because we're also obsessed with LGR, to think about devolution as the easy bit, but actually it's a complex process, and there are things you need to get right before you can, if you want to make it work properly. Before we get into that and then hear from Laura, a couple of bits of housekeeping. We are recording the presentations today. We will not record the Q&A. So it's a Chatham House conversation of that bit, and I hope people feel free to contribute. We'll have plenty of time for Q&A after Laura and I run through some of our initial thoughts. Do feel free to add questions to the chat, and we'll sort of collate those and play them back to Laura at the end. So before I introduce Laura properly, I just want to run through very briefly some of the findings from the piece of work that we're publishing with Browne Jacobson today. As I said, this looks at some of the practical realities of how devolution operates. It's on the website, it's on the LGIU website, so do please go and have a look. But just very briefly, I guess we found a few key lessons from that. Next slide, please, Jen. And yeah, the essential argument is that basically it's not easy, right? There's a huge capacity crisis, capacity gap potentially in devolution. You need to find the appropriate resources to make this work properly. Success or failure depends on having the right legal governance and administrative capacity in place. There isn't a lot of that to go around, so it needs to be addressed before it's too late. 5 key lessons. Next slide, Jen. You have to recognize that the new strategic authorities, combined authorities, are new organizations that really need to be built from the ground up. You're starting from scratch. The capacity problems put a significant burden on teams across the new devolved organizations. There's an awareness gap. There's very low public understanding of these new entities, and that creates democratic challenges and scrutiny challenges. That once it starts moving, it moves fast. It's incredibly tight guidelines and ongoing uncertainty around some of the statutory instruments and guidance. And like so many things, in the end, this is about, yes, it's about governance, yes, it's about capacity, but it's also about relationships, and it's essential to put those relationships in place. So that's some of the lessons from that research. As I said, it's on our website, and you can find it today. But we're here to talk about the devolution bill. Now, I'm really pleased to hand the mic over to Laura to get her thoughts on the bill, which has been out in the wild for over a week now. So we've all had time to digest the 330 odd pages that it constitutes. Laura, as I said, is a partner at Browne Jacobson. She heads up the public law team there and is the head of the Insurance and Public Risk Department and executive lead for Wales. She's a hugely experienced public lawyer who's advise clients on some of their most important and high profile issues. We've done a huge amount in education and health and audit and sports, but particularly for our purposes in local government, and has been quite involved with devolution in some of the places where it has already happened. So there's no one better to give us some insights into where the bill takes us forward compared to the white paper, how, what the questions remaining are, her sort of analysis based on as a consultant, there's still a whole parliamentary process to go through. But for where we are right now, Laura, over to you.
Thank you. I'm going to try and be relatively brief so that there's plenty of time for discussion and questions, but it is a lengthy bill, as Jonathan said, 300 and odd pages. The good news is a lot of it is already relatively familiar for people who have done devolution recently, in the sense that a lot of the powers that are being flagged as new are not really new and were being given to combined authorities anyway. There's also a lot still missing, I have to say, in terms of within the bill, lots and lots of secondary legislation making powers. And having now gone through the bill in its entirety, lots of areas where I think there will be extensive secondary legislation, which we obviously don't have yet. So, and I also am afraid to be the bearer of bad news that this will not in any way simplify anything to do with devolution. In fact, I think it probably complicates it, at least from a legal perspective, in that there's even more places where this law is going to be found, the law that applies to devolved bodies. There's the other stuff in there as well, a little bit on LGR, but it really is a little bit. Obviously, the establishment of a new audit body, the other much sort of touted bits and pieces around upward only rent review, community governance, etc. But a lot of that is still left to be defined. So, if you just go on to the next slide, Jen, I'm going to focus on devolution, but not exclusively on that, to answer the point that someone's already made. A lot of the bill does deal with devolution, and the more complex bits of the bill deal with devolution. So I'm going to start with a little bit of a look at governance and strategic authorities. Then I'm going to look at powers and functions of strategic authority. Then I'm going to deal with everything else. And if my timing's right, it should be about 5 minutes on each, but probably won't be, in truth. So strategic authorities, as was sort of heralded in the white paper, there are going to be these different types of what we're now calling strategic authority. Some of them legally are combined authorities or combined county authorities. Some of them are not. So single foundation strategic authorities are effectively one council, so unitary district or county council designated strategic authorities. So at the moment, we think that's probably just Cornwall, that's a single council that's already kind of got some powers. It's not yet designated as a strategic authority, though. It's just been given some powers by the government, and so would need to be there we go. The slides are moving around and are now small. Could we possibly get the slides back?
No, bigger.
There we go. So I think, as I say, that's probably just Cornwall, and I'll come back to those in a moment. There's a combined foundation strategic authority, so that's effectively a combined authority or a combined county authority without a mayor. So Lancashire, Devon and Torbay. Mayoral strategic authority, a combined authority. So mayoral strategic authorities, and then established mayoral strategic authorities, which are combined authorities, combined county authorities with the mayor, which have been designated as established, and also importantly, the GLA, the Greater London Authority. And the way these were all heralded, as I say, in the white paper, the way they interact, though, is what's a bit more interesting and kind of a little bit more of the detail out of it coming out of the bill. So for a single foundation strategic authority, the council itself needs to consent to this. And the Secretary of State can confer functions using regulations. It's not a combined authority or a combined county authority. So to become either a combined foundation strategic authority or any of the others, it would have to go through a process to create a combined authority or combined county authority. So it is a different legal form to any of the others. And it's interesting that they're actually maintaining it, because I'm not sure, they said that there would be foundation strategic authorities, which I think I took to be similar to Lancashire, so where there's more than one unitary, and that over time, more than one council, and that over time they would move to become combined authorities when unitary change had happened underneath with a mayor. I hadn't really anticipated they'd look to be retaining single foundation strategic authorities. And as I say, I think it may just be Cornwall that's in this place at the moment, but it is obviously opening up the possibility for others to be in that place. So that's interesting. In terms of then, in addition, you've got Schedule 1 containing powers for the Secretary of State to make a proposal in relation to a combined authority or combined county authority. That's either for new ones or to expand existing ones and to add mayors. So where I was talking about these combined foundation strategic authorities, which are already combined authorities or combined county authorities, they can progress to become a mayor through proposals that are in Schedule 1. As I say, with a single foundation strategic authority, it would have to become a combined authority, combined county authority first. This also includes the power that was talked about in the white paper for the Secretary of State to, in effect, force these changes or force new combined authorities, combined county authorities to come forward, or force a combined foundation strategic authority to acquire a mayor. So the Secretary of State can only do that if there are no relevant proposals submitted from the area, or the proposals submitted are not considered by the Secretary of State to be viable. And if the Secretary of State's had regard to the statutory test, which is there, the need to secure effective and convenient local government in relation to the areas of competence. So in effect, not only can the Secretary of State make their own proposals where no proposals have been submitted by the area, even if proposals are submitted, but they're not to the Secretary of State's liking, they can make their own proposal in relation to an area. So that's worth noting as well. If you can just jump onto the next slide, Jen, please. To become an established mayoral strategic authority, this requires a proposal from a combined authority or combined county authority. So the mayoral, it has to be mayoral already, obviously, and sorry, that should say CA or CCA, has to then submit a written proposal to the Secretary of State. It needs to ID provisions that they would like to have applied to them, which shouldn't apply to them, or which would continue to apply to them. So this is, I think, it talks about provisions, but I think it's meaning legal powers that should and shouldn't apply. So in effect, when you become an established mayoral strategic authority, or you say you would like to be one, you can say, well, I would like these additional powers, or I don't want that power anymore. I don't think that provision should apply to me anymore because I think I should have some more freedom. So potentially removing restrictive provisions. If the Secretary of State doesn't think it's right to designate, they must have to give reasons for that. And then if there were to be a second consideration, they'd need to start the process all over again. So the mayoral area would need to apply again, in effect. There is, I think the designation, it doesn't say that it would require secondary legislation. So it'd be interesting to see whether it does. I think in effect it probably would, because there'd potentially be additional powers, as I talk about, and that would definitely need secondary legislation. So I think in effect there would probably have to be secondary legislation to designate an established mayoral strategic authority. And interestingly, there is a prohibition from making regs removing an established mayoral strategic authority, though it could still be abolished or merged. So once you're an established mayoral strategic authority, you stay an established mayoral strategic authority, or you're abolished or merged into something else. Those are the only options. You can't kind of drop back down to just become a mayoral strategic authority. So that, again, is interesting because it's one way only, which is a little surprising. Obviously, remember, as we go through, some of these provisions might drop off or change. So there's a provision for simple majority voting. Again, that was included in the white paper, that the idea that all strategic authorities, or all combined authorities and combined county authorities at least, would move to a process where there would be simple majority voting on everything, except in very rare circumstances where there's been carve-outs, and the example given in the white paper is around trams. That majority voting would need to include the mayor in the majority where there is a mayor. But interestingly, that provision remains subject to provision made in any other enactment, so whenever passed or made, which would include establishment regulations and orders for any combined authority which is created. And in some cases, many cases, where there's carve-outs from the standard position, they're included in the establishment regulations. So it won't actually change the status quo for a lot of current combined authorities, combined county authorities. There is a power to make regulations dealing with simple majority voting and Schedule 23, but are they really going to make individual provision for every combined authority that has carve-outs? I mean, I guess maybe they are, but that is going to mean a lot more sets of secondary legislation. So for new combined authorities, combined county authorities, strategic authorities, this will be the position. It doesn't apply to single foundation or strategic authorities, which are one council, or to the GLA, because their voting is obviously different and set down in different parts of local government legislation. But for all of the strategic authorities, this will be the position going forward as the default. But obviously it would still be possible to have carve-outs in any secondary legislation. And as I say, for any existing combined authority, combined county authority, this does not actually do away with whatever you have agreed. It may be that secondary legislation is going to be introduced that will do that, but right now it doesn't do it in the bill. There are also provisions which seeks to ensure powers to make secondary legislation about combined authorities, combined county authorities are not limited by other provisions or powers. I'm not at all sure how this works. I can't get my head around it, which is a bit of an admission for a lawyer. Whether it will be acceptable and what it's even seeking to achieve. It's a really confused provision that doesn't make much sense to me. I think it's badly drafted, and it's very complicated. And I don't know what it's trying to say. In effect, I think it's trying to say that if we create secondary legislation under the acts that are being amended, so the localism, the Levelling Up and Regeneration Act and the Cities and Towns and whatever the other one is Act, then they can deal with anything, and they're not limited by previous provisions and powers where they apply it to combined authorities or combined county authorities. But if that is what it's seeking to achieve, so I'm not sure the drafting actually achieves it, although I think it goes part of the way there, but it's clearly incredibly wide. So any sort of pre-existing limitation can be done away with in secondary legislation. That seems quite hard, quite broad, and probably not something Parliament would expect. So watch this space on that, because I don't really understand it. It doesn't really seem to reflect anything that was in the white paper. So it's a bit confusing to me. And then there's this power to appoint commissioners, which wasn't referenced in the white paper specifically. And this is a power for mayors to appoint up to 7 commissioners, 1 for each of the areas of competence, to assist the mayor on their own or on CCA functions. So there's various provisions around then commissioners and expenses and things like that set out in Schedule 3. But note that there's powers to issue guidance, which mayors, combined authorities, combined county authorities must take account of when appointing commissioners, and several sets of guidance at that. So again, there's guidance that we don't have here, which will provide more information about commissioners and how they're supposed to operate and where they can be appointed from and all that kind of stuff. Certainly, it looks like the intention is for them not to be members of the constituent councils, but to be independent individuals who kind of come along to help and can carry out some of these functions on behalf of both combined authority and the mayor. But this guidance will be illuminating when we receive it. Next slide, please, Jen. So just rattling through the last ones in this section is power to make payments to members of the CCA with special responsibilities, generally provided for in newer establishment orders for newer combined authorities anyway, but it's there for those that don't have it. There are several provisions then around precepting powers to borrow and levying powers in respect of transport, but these are standard powers that were being given to combined authorities and combined county authorities anyway in their establishment legislation, and nearly all have got them. I think all, in fact, have got this. Secretary of State is able to make regulations under Schedule 23, which I'm going to come to in more detail under Schedule 23, which confers further powers on the GLA, the mayor, and the functional bodies of the GLA, which are listed there. So that is interesting because it allows Secretary of State to kind of add powers. And as we'll come on to in a moment, when we look at powers and functions and how they're going to operate, there's also a power to kind of move them around amongst those bodies. So that's different, quite interesting in terms of London, where I know there's been calls for sort of changes to the way the GLA operates. There's provisions around not being able to hold an office if you're a mayor, if you hold office as a mayor, if you're an MP, a member of the Scottish Parliament, Senate, or the Northern Ireland Assembly. Again, I think directly to address the fact that a couple of people who stood for mayoral positions more recently were MPs at the time. So I think that's to kind of make it clear that if you're appointed as a mayor, you cannot carry on with your role as an MP. And there is provision here for a distinction between mayoral functions and combined authority, combined county authority functions, and that some will be one and some will be the other. Again, that is something that's provided for already in establishment orders, and the legislation is literally copied across. So there's some interesting stuff in that bit. Some of it is kind of stuff we've seen before. There's some of it that's a bit confusing, but definitely a few interesting points. If we just move on, Jen. Moving on then to powers and functions. Just skip on again. So it's interesting how they've done this, now that I've got into it and got my head around it. They've talked about these 7 areas of competence, and they're listed there. And they refer to them as areas of competence. And this is trying to, I think, move towards language, which is a bit more similar to language used for Wales and Scotland in terms of more true devolution. It still isn't that, but that's what they're trying to achieve here, I think. And Schedule 23 then provides a pretty wide power for the Secretary of State to make provision via secondary legislation of additional eligible functions within these areas of competence via regulations, and for modifying any functions exercisable by strategic authorities within a class of strategic authority. And then what's interesting then is eligible functions is defined incredibly widely. So it's a function of a public body, so it has to be an existing function of a public body, but it can be a function which relates to any area or any aspect of one of those areas of competence. So obviously that's huge in terms of those areas of competence. And it can include a power to make bylaws, but not otherwise to make legislation. So what this is setting up is a situation where into the future, as mayor or the government decides they want to give more powers to either all strategic authorities or some classes of strategic authorities, that the Secretary of State can, by secondary legislation, do that, really to any power that's held by a public body within any of those broad areas of competence can be devolved to the strategic authorities, and that can include a power to make bylaws, but it's very clear it's not allowing you to make your own legislation otherwise, which would obviously be a different thing. So I think that's quite interesting because, again, it's quite wide, it's quite indicative of the ambition probably of where this could go into the future, and it allows lots of things to be passed off through secondary legislation, which can be controversial sometimes because obviously that has less scrutiny then ultimately through Parliament. If we just jump on, Jen. And then Schedule 23 also allows for functions to be moved. So the Secretary of State through secondary legislation can move functions around, either existing ones, which we'll come on to in a moment, that are provided for in this bill or others, or new ones, which they can create, as I've just said. So they can move them from a strategic authority to a mayor outside of London, from a mayor outside of London to the strategic authority. In London, as I said, between the GLA, the mayor, and a GLA functional body, can move them all around. And interestingly, they can abolish a public body if it will no longer have any functions, which I think is quite interesting. I don't know whether that means they're thinking. I think it may be, to be kind of less cynical about it. I think it may be that where, for example, strategic authorities have been created, so foundational single strategic authorities, they will have been created. They'll be a legal entity. And it may be that it's to enable abolition of that, although I don't think that quite works. But it could be that, again, there's an idea of abolishing some of the GLA functional bodies, or potentially in the future to abolish strategic authorities and just have mayors with powers. So I mean, it's interesting because there's no sort of indication of what that would be used for or where that might go, but that power is there. Schedule 23 also provides for pilot schemes for functions. Again, this was mentioned in the white paper. So if there's a proposal that a strategic authority should have some additional powers, it can be piloted in some areas, and there would be regulations providing that. It sets out the power of mayors to seek changes to the law, changes to funding, or other changes for strategic authorities. So in effect, they can ask for that, and the Secretary of State will consider it. And then Section 54 sets out a prohibition on secondary legislation removing functions which have been given to strategic authorities. So whether that's functions that are given in this Act, in previous legislation, in previous sets of regulations, so establishment orders as well, I don't think that's what they mean, because that's going to cause them problems if they do want to change anything that's in establishment orders around voting. But also any new legislation that's made under this section, in effect, once the strategic authority has it, it can't be taken away from them. Although the strategic authority, apart from for pilots, there is an exception for that. Although the strategic authority can be abolished, as we've just discussed. Next slide. Thank you. So then the powers, in addition to creating this ability to give over additional functions or allocate them between bodies, the bill also introduces new powers. Now, they're not new, most of them. And so I'm going to rattle through them because many of them are powers that were being given out on a standard basis to combined authorities prior to this bill, but it was just being done in establishment orders rather than through primary legislation. So most of them aren't new. So the extension of the general power of competence, much heralded, not new, was being given to all combined authorities, combined county authorities and mayors anyway in establishment orders, but it's there in primary legislation now. What is new is the power of mayors to convene local partners, and note local partners is yet to be defined by a set of regulations. So we don't know exactly who they can call to the table yet. That could be anything or anybody right now. It's not limited to public bodies, so it could be anything depending on what the regulations define it as. And then powers to collaborate with other mayors, and duties as well to respond if a fellow mayor asks them to collaborate. And the provisions here are really complex. It's around kind of putting out notices to local partners having to respond, putting out notices to other mayor, provisions for if there's multiple mayors wanting to work together, how they have to respond to each other. The whole way in which it's worked, in where it has worked, this power to collaborate, is because it's been done through relationships and softly, and this sort of takes a whole huge complicated framework to it. Personally, I don't think it'll last as the bill progresses. It's overdone, but I can see what it's trying to get at. And as I say, a bit of uncertainty at the moment around what local partners are. Moving through each of them, I'm not going to run through all of these because these slides can be shared and it's got it all there, but through each of them, the competencies, there's various different provisions. So some of it's new, so like the regulation of provision of micro-mobility vehicles here, that is a new power that will go to strategic authorities and actually to local authorities where there is no strategic authority, so everybody's getting this. Most of it, though, as I say, isn't new, and there's some new restrictions on disposal of land by Transport for London. It's not a full restriction; they just have to consult some more people before they do it. Nearly all of these, the duty of constituent councils to act in accordance with local transport plans is new, so that's a new duty on constituent councils rather than combined authorities. That's new. Interestingly, more new stuff that applies not to constituent councils, not to combined authorities, I'd say, than to it. Next, Jen. Again, skills and employment, nothing new there in terms of what was being given out routinely. Some stuff in housing and strategic planning is, so the ability to call in planning applications of potential strategic importance is new. It mirrors the powers of the mayor in London to do the same, and it's because of the introduction of the responsibility now on mayors to put in place strategic planning documents, which is in the Planning and Infrastructure Bill. So it's in light of that, effectively, if something is contrary to that plan, it can now be called in for determination by the mayor in an area. So that's quite a new significant power, to be fair, that's going to be given to everybody. A power to charge CIL going along with that, I think, again, is new, and again, quite a significant new one, but everything else there is not new. Economic development and regeneration, local growth plans, again, mentioned in the white paper, responsibility on mayors to produce and publish those, that is new, but nothing else really in this section is. If you just jump on Jen to the next slide. So as you can see, a whole swathe there of not new, not new, not new. Public safety, interesting here in that there's nothing new in terms of the functions, but what is new is that if a police and crime commissioner or a fire and rescue authority meet the qualifying criteria, then it automatically, the powers of those entities will go to the mayor, and the qualifying criteria are that their boundaries are contiguous effectively with the strategic authority, and that can be one or more, so where a strategic authority takes in two. So in the East Midlands, for example, there's 2 police and crime commissioners, but they're fully contained within the boundaries of the East Midlands Combined County Authority. And the same for a couple of the, 2 fire and rescue authorities as well there. They have to have contiguous boundaries, and the Secretary of State also has to have made an order transferring it, but it does put the power for that to happen in the hands of the Secretary of State, whereas before it was more that it would be by agreement and by consent. So that's a change. So that can be potentially forced through now as well, that those powers would shift up to mayors. Don't think that was particularly mentioned in the white paper in quite that way. So other provisions, thanks, Jen. So moving on now from strategic authorities to look at pretty much everything else that's in there, which is much shorter. As you can see on the previous bit, where there's all those swathes of not new powers, whilst there's lots and lots of legislation there, because it's bringing these powers into primary legislation, and that's what most of the hundreds and hundreds of pages of the bill are. So they're not new powers, but they are enshrining them in primary legislation and applying them the same to everybody. Interesting point on that, just before I do move on, is that there's nothing again to say that secondary legislation which already exists, so establishment orders of already existing combined authorities or strategic authorities that conflict with those, how that is to be resolved is not clear. Clearly, the Secretary of State can make secondary legislation which could deal with that. But at the moment, it's looking like to get the standardisation that they're talking about in the white paper, they're going to have to do loads and loads and loads and loads and loads of secondary legislation, amending existing secondary legislation to bring it all into line. can't really see that's what they intended or where they wanted to be, but that seems to be how they're setting themselves up. But again, that may change as the bill progresses. I think it's that they don't really know what's in the secondary legislation that already exists. But other provisions then. So local government reorganisation, there's not loads in there that applies to it. It does, though, reintroduce the power to direct the making of proposals for a single tier in local government, which the white paper said they would do. And it makes a consequential provision to allow conversion of a combined county authority to a combined authority when that's needed as a result of local government reorganisation, because combined county authorities only work where there's a county and some districts. Obviously, if counties and districts are to disappear and you're going to have unitaries, they would technically need to be combined authorities. So that provision is now made to enable that to happen. So there's nothing else on LGR. The same process as always was will continue to be carried through. That's literally all that's in there on LGR. The abolition of the committee system, again, not mentioned in the white paper, but talked about before it happened, is all set out in Schedule 26. I'm not going to go into it in loads of detail. It's fairly straightforward abolition and a move to executive system for everybody. Neighbourhood governance, interesting, much heralded in the white paper, lots of talk about what it would be. Literally nothing on it in terms of substance. The powers are there to make regulations, but there are no regulations currently. So we need to see exactly what that looks like and how that's going to work. But at the moment, there's no specifics on that at all. The guidance that the government's put out seems to suggest there's more detail to it than there is. There isn't in the Act. Literally, it's just a set of powers to make secondary legislation that will pick up neighbourhood governance. Provision of a supplementary vote system for mayor and police and crime commissioner elections, not mentioned anywhere before the bill came out, so a bit of a shock, but again, been much talked about since. Provision for community right to buy for assets of community value and for protection of sporting assets of community value, building on the legislation that's already there and expanding it. Introduction of local audit office. There's 3 schedules dealing with that. I haven't gone into that in lots of detail, but again, that was talked about, although only in one line in the white paper, but it has been being talked about behind the scenes for some time in terms of a slightly confused picture for local government audit across a number of bodies since the abolition of the local audit office, which is effectively what they're recreating here. And then the abolition of upward-only rent reviews, which again was very much not expected, I don't think, until the bill came out. The kind of outpouring of animosity that's accompanied it makes me think it's unlikely to make its way all the way through the bill. It's incredibly controversial, a huge problem for all sorts of pension funds and things like that. It's designed to protect high streets, apparently, but it's a bit of a sledgehammer to crack a nut because it applies to absolutely everything. So, as I say, I highly doubt that will make its way all the way through the bill without either coming out, because it'll just slow the bill down too much, I suspect, or and being promised to be created somewhere else. I think that's probably what will happen, or being significantly amended. We had this with the levelling up and regeneration bill, in that some of the planning bits of it were so controversial it just took forever. They can't afford for this really to take forever, so I think that might end up coming out. So just a couple of concluding thoughts. I know I've taken quite a long time, and so I don't need to rush through these, but effectively I've covered most of these before. In effect, there's some interesting points in there around why they've got an abolition power, what a commissioner is going to be able to do, who might they be, say all sorts of issues about pre-existing legislation and how that's going to be changed and whether it's going to be changed on things like simple majority voting, but also where there might be conflicts between what's been provided before and what's here. Certainly the newer combined authorities have got exactly the same powers, but some of the older ones, the wording is slightly different. Just last one there. I think that's pretty much everything. So yeah, so I think there's this concept of areas of competence is very interesting. The breadth of power to introduce new provisions is big. But I think there's all sorts of things that, this was supposed to simplify things, having one set of powers. It really isn't going to, because for now, unless and until we see more on this, you would still have to look at establishment orders, primary legislation, and then lots of secondary legislation under this bill to work out what's been conferred where. And it won't be the same for every combined authority, because it will depend on what type of strategic authority you are. So I think it's interesting. I think it's perhaps in some respects not what was promised. And I think there's still probably questions to be answered through secondary legislation. into the future for some more of the detail about mechanically how this will happen. But there is a few interesting things in there that, you know, again, are a bit unexplained at the moment, and we'll see where we go.
Brilliant, Laura. Thank you so much. That was a tour de force of taking us through an unbelievably weighty thing in not much time at all. So thank you.